task force conducted a comprehensive study starting with the Seventh Circuit's Committee on Civility, headed by District Judge Marvin Aspen of Chicago, which started in 1989. The Seventh Circuit's interim report was published in 1991 at 143 FRD 371, and the final report was published in 1992 at 143 FRD 441. The movement and momentum provided by the Seventh Circuit has now led 26 state bars and 58 local and voluntary bars to adopt some sort of standards or codes of professional conduct that now address civility in the profession. The DC Bar Task Force report details for each state and each of those voluntary bars just what has been done, so it's a very valuable resource as we go about looking in the District of Columbia about what we might adopt in terms of local rules changes or the possibility of some sort of standards that we might adopt. The DC Bar Task Force surveyed almost 1,000 lawyers in DC who responded to questionnaire, as well as all of the trial judges of both Superior Court and the District Court. And there are a couple of things that they found that I thought were interesting to mention here. 69% of the lawyers said lack of civility is a very important problem or a somewhat important problem. 78% of those responding said discovery proceedings are the activities in which incivility had most frequently been encountered. I was somewhat surprised that 50% of the lawyers responding reported encountering incivility in the courtroom, either frequently or at least occasionally. I thought that I generally can control incivility in the courtroom, and I do know that I read some unbelievable deposition transcripts about what goes on between lawyers at depositions, but I was a little surprised at the large number of lawyers that were complaining about incivility even in the courtroom. Of the 60-something judges that the DC Bar talked to about civility, 89% of the judges reported witnessing incivility between lawyers either frequently or at least occasionally, but only about half of the judges, as opposed to 75% of the lawyers, thought that civility was either a very serious or moderately serious problem. I do want to, and I will ask Judge Easterbrook, as I mentioned to him before, that I would ask him what he thought the impact, if any, had been of the Seventh Circuit's civility study and standards. I want to mention one other thing in opening before I turn it to the primary presentations by each of the panelists. I'm going to do something I've never seen a district judge do before, and I have never done before, but I'm going to give you citations to two cases in which I have been reversed, where I tried to deal with discovery problems, and I tried to enforce discovery rules only to be soundly reversed in both cases. The first case I'll give you the citation to is Shepard versus American Broadcasting Company. The DC Circuit's opinion is 62 F. 3rd 1469. My own opinions are at 151 FRD 179 and 151 FRD 194, as well as 862 F. Sup. 486. I had entered a default judgment against ABC based on document destruction, manufacturing false documents, filing false and misleading affidavits, and other misconduct that I found committed both by the defendant ABC and by the major law firm representing the defendant. The Court of Appeals first held that I had to find the misconduct by clear and convincing evidence, and then proceeded to pick apart each of the various factual findings that I had made until they concluded that what remained was insufficient for me to have entered a default judgment against ABC. The Shepard case was decided by the Court of Appeals August 25th, 1995. 2 weeks earlier, unfortunately for me, on August 9th, 1995, I had just entered my final judgment granting sanctions against the District of Columbia in the newest case in which I was just reversed 2 weeks ago, Bonds versus the District of Columbia. The circuit number is 95-7207, decided August 23rd, 1996. Bonds was a major class action sex discrimination and retaliation case brought against the D.C. Department of Corrections by guards. In the midst of numerous discovery problems, I granted the District of Columbia a second enlargement of time for answering interrogatories listing witnesses who had knowledge of the case and briefly describing their knowledge. At the request of the plaintiffs, I made the second enlargement of time conditional that if DC failed that time to respond to the request for answers to interrogatories, they would not be able to call any fact witnesses at trial. I entered that order on November 2nd, 1994. The deadline that DC had asked for, November 7th, was imposed then in my order of November 2nd. November 7th came and went. DC didn't do anything. They didn't move to extend the time. They didn't respond at all. They finally responded November 10th. And in their response, they said the names of all the witnesses were in the deposition testimony and the documents that had been produced during the course of the discovery. I found that response was wholly inadequate, and at the next status conference, I said that unless DC successfully moved me to reconsider and produce the names, they couldn't call any witnesses at the trial. Finally, on December 12th, DC did move to reconsider. They filed a supplemental interrogatory response with 1,000 names. They admitted they prepared the list of 1,000 names by having two paralegals spend 2 weeks going through all the documents produced and deposition testimony and pulling out every name that was mentioned, no matter in what context, including dead people and others. I then had a hearing and I found that DC was just playing games. I found that the 1,000 names are bad faith, so I refused to reconsider, and I conducted the trial without DC being able to call any fact witnesses. The plaintiff still had to prove their case, but the defendant was prohibited from calling any fact witnesses. The Court of Appeals unanimously reversed me. They held the 1,000 names, quote, may have been overbroad, but it does not follow that the district was not attempting in good faith to comply with an interrogatory requesting it to identify all persons with knowledge of the case, unquote. Although the Court of Appeals panel said a district court has broad discretion to impose sanctions for discovery violations, they held that I abused my discretion by imposing the very sanction that I said I would impose in my November 2nd order. They didn't find my November 2nd order was improper per se, but they found it was improper for me to enforce my own order. And it was an abuse of discretion for me to enforce my own order. So I stand here today, having been roundly reversed twice in 1 year for imposing sanctions for what I found to be discovery abuses. And I ask you, why did the Federalist Society invite me here today to speak on this topic of discovery abuse? Probably more significant is, why did I accept? I will admit I accepted before my most recent reversal. But I think with that opening, I give you some idea of where I stand on the subject. Shepard was settled on remand from the Court of Appeals under terms that were never disclosed to me, so I don't even know the settlement. I can't say any more, and I've probably already said too much about the current DC case because it is back before me, assuming rehearing in bank is not granted, which the plaintiffs are seeking. I do want to say that I think we have a great panel to talk about the topics today. First of all, John Coale is still on a plane on the runway in New York, but we were fortunate that his partner, Diane Cooley from his firm, is able to substitute for him and give us the plaintiff's bar perspective. Diane also teaches civil discovery at Georgetown University Law School, and she's well qualified to talk about the topics we will discuss today. Judge Frank Easterbrook needs no introduction to the Federalist Society, but I'm pleased to have him here first because he has been a leader in many areas about discovery, abuse, and reform. And of course, he also serves on the Standing Committee on Rules. Two other members he pointed out to me at lunch are here from the Standing Committee on Rules at the Judicial Conference of the United States. And Frank's views are very instrumental in looking at our overall federal rules that try to make some sense in this area. We also are very pleased to have a solicitor from England, John Heaps, here with us today. John is a partner in Eversheds, the second largest legal practice in the United Kingdom. His career has brought him into contact with the United States on many occasions, acting for American companies that were involved in proceedings in Europe and in English companies involved in litigation here in the United States. He's vice chairman of the Civil Litigation Committee of the International Bar Association, and John is going to tell us about some very dramatic changes that are occurring in England in terms of discovery reform. First, we'll start with the plaintiff's perspective from Diane, and then Judge Easterbrook will tell us a little about the Seventh Circuit. I haven't asked him whether he would have reversed me in my two cases, but he can give us some perspective about the Seventh Circuit. And then last, we'll hear from John about what's going on in England, and some very dramatic things are about to happen in England. We hope to save plenty of time for as many questions as we can handle at the end as well. Diane?
Hi, as Judge Lamberth says, my name is Diane Cooley, and I'm a partner to my sometimes infamous, sometimes notorious, and always flamboyant partner, John Coale. I doubt I'll be as entertaining as John would have been, but I am substantially lower on the totem pole at our firm, which means I'm a lot closer to discovery, because as everybody knows, the higher up you go, the easier it is to kick that stuff to the bottom. So I'm much closer to this stuff than he is, and I do teach civil discovery at Georgetown. I try to teach a realistic class because it's a practice class. It's like trial practice, and you're trying to teach the students something they can actually use instead of, riparian rights or something that, they're probably never going to have a chance to use in their real lives. I always start the class by telling them something that, maybe crushes their little happy souls, by telling them that civil discovery is the worst part of civil litigation. And unfortunately, it's also the biggest part. It's the part that takes the most time in your life. Particularly as a new associate, I would say you probably spend 90% of your time doing that. If you're lucky, you have 10% of your time to do something else. I used to work at a defense firm, and I'm going to let it remain nameless because I might tell you a little story about working there later. I worked at a defense firm in Boston for a couple of years, and for 2 years, for 730 days, all I did was discovery. That's it. Nothing else, just discovery. Coding, coding, coding. So anyway, I try to tell the students that, this isn't going to be fun. And I try to also tell them how to do it, how not to get tripped up, how not to make a game out of it, and how to do it right, and how not to let somebody blindside you. And it's hard to walk the line and tell them how to do it, and do it ethically, and do it well, without appearing to teach them how to be sneaky. Why is civil discovery the worst part of the practice? Because it's not civil. As Judge Lamberth pointed out in his opening remarks, it's nasty. I mean, it's almost universally nasty. Something about it brings out the worst in people, maybe because it's so damn boring and it's so onerous. No one wants to do it, and everybody is nasty about it. Discovery is abused, and it's abused by both sides. It's abused by plaintiffs and defendants. It's almost as if by being civil, you reveal a weakness, either in yourself or in your case. If you are nice and you say, sure, take another 30 days that everybody needs to answer those interrogatories, the other side is going to somehow perceive you as being weak. But wait till you need those 30 days, which you will. You better hope that you were nice to those people on the other side. It's really a shame, because at this time in the legal profession, when everybody's being attacked from the outside. And I think it's plaintiffs and defendants alike are being attacked by the public. The public perception of lawyers is so bad, it's an all-time low. There's a new lawyer joke every week. And I don't know what your experience has been. My experience is that nobody has any qualms about telling you a lawyer joke, even though you're a lawyer. They somehow, think it's funny to describe you as a shark or, a sleaze or whatever. And at this time when lawyers are being attacked by everyone in society, you would think people might pull together a little bit within the ranks and say, let's at least be nice to each other. But nobody really seems to do that. And it's interesting. We practice all over the country, and recently we've practiced a lot in the South. Our firm is one of the members of the plaintiffs' legal committee in the Castano case, the big tobacco case down in New Orleans, and that is a different world. It is a different world in New Orleans. It is a different world in the South. People are still very cagey, and they're good adversaries in court. But when they're dealing one-on-one, they're real nice to each other. And it's so different. It's just not like practicing here. And boy, it's different. And I found the same thing in small towns in the Midwest. People are nice to each other. And you go in there, and, you're ready, and people are disarmingly nice. And the practice of law is alive and well. I mean, it can be done. It can work that way. It takes a little getting used to, but I think that if people tried, we could do it that way. The premise of this discussion seems to be, and I'm biased, we do all plaintiffs' work, which some of you may know. We do no defense work at all, so I am biased. The premise of this discussion, as I read it in here, is, are plaintiffs abusing discovery to get settlements or get the upper hand or something of that nature? And I've got to say, I really disagree with that premise for a couple of reasons. The first one being that, in my experience, it's the defendants who are kind of using the discovery for gamesmanship. There's two kinds of abuses in the discovery system. One is sort of a willful, we're not going to give you that. And the other is, those interrogatories that you served on me in January, yeah, I'll get you those. I think the first kind is the kind that defendants more often engage in, and the second kind is the kind that plaintiffs more often engage in. And that's sort of economic incentive. Plaintiffs work on a contingent fee basis. There's not a whole lot of incentive to sit down and spend, 3 weeks drafting answers to interrogatories. The truth is that the incentive, I think, is more on the defendants to abuse the discovery system by not revealing what they have, not giving up what they have. And our practice is an injury and death practice, so I can't really speak to securities litigation or corporate defendant versus corporate defendant. But the fact is that defendants tend to be the people with the manpower, with the resources to fight the protracted discovery battles. And every week, it seems, you open the National Law Journal or the Legal Times, and you'll see in there an article about some discovery abuse. Recently, there was one in there, and I hope I'm not offending anyone, but there was an article about Chrysler refusing to disclose other incidents where someone had been injured by, I don't know, a door that wouldn't latch or something like that. And they got sanctioned $25,000. I think originally it was much greater, and the judge reduced it when they did disclose those incidents. This case involved a woman who was paralyzed. I mean, these are not small matters, and the plaintiffs had a right to that information. And I think that's what gets lost sometimes, is that we're really dealing with people's lives. We've had a similar experience where we had a water heater explosion where a child died and another child was severely burned. And we asked for other instances of water heater explosions of this same model of water heater. And we got That's not relevant. It's not calculated to lead to the discovery of admissible evidence. You can't use it at trial, so we're not going to give it to you. Then eventually they gave us 5 or 6 incidents. We went out on our own and really did a nationwide canvass of the court system, and we found 16 almost identical cases, all involving children under the age of 9. And the judge was so livid. I don't know if any of you practice in the Eastern District of Virginia. It's a rocket docket, and there's nothing quite like the rocket docket in the Eastern District of Virginia. It's Judge Williams, and man, let me tell you, Judge Williams wants to move a case. That thing's going to move, and he decided to let all the evidence in of these prior explosions, and I think in part because he was furious. He was furious that they hadn't disclosed it, and he was furious that the dispute was before him, that he had to hear it. It was a waste of his time. But that's the kind of experience that I've had and that my firm has had. We've also been a part of the, as I said, of the Castano case, and everybody has been, I'm sure, exposed to these documents, these smoking gun documents that are now, on the internet and on every street corner in every major city in the United States. You can find these documents that were stolen from one of the tobacco defendants, Braun and Williamson, by one of their apparently disgruntled paralegals, and were just thrown all over the world. And those documents were a subject of intense debate because, they were stolen, and let's face it, that's wrong. But the fact is that in 30 years of discovery, those documents had never, ever been turned over. And they were relevant, and they did come within requests that people had made. And in fact, I don't have it handy because I didn't think I'd be here today, but we have a list in that case of all the cases that we know of where discovery requests were made that would have captured those documents, and they were not produced. The discussion about those documents has focused on how wrong it is that they were stolen. But what the discussion hasn't focused on is why were they never turned over before? Sure, it's wrong they were stolen, but let's look at what they say, and let's look at where they came from. What was going on here is these guys had a coding system that involved coding things work product that weren't. And that is actually in the documents itself. There's a document that basically says, well, we'll call this stuff dead wood. Everything that's dead wood, is going to get filed in this special filing system, and we're going to stamp it work product, and that's how it's going to stay out of the hands of plaintiffs. And it actually says in this document that we have, it says, we've got to keep this stuff away from the plaintiffs. That's abusive. That is very abusive, and that is an extreme example, and I don't think that goes on much. I'd say that's pretty extreme. But I do believe that gradations of that go on all the time. We see it all the time. And now I'll tell you the story about when I used to do defense work. And I was this brand new associate and the partner. We had a big client, corporate client, who had a lawsuit pending. 5 minutes later, the partner was in my office, and he said, "What the hell are you doing?" And I said, "What do you mean?" And the client's very upset. But, you've been calling him, bothering him about the interruptions. I said, "I'm trying to get the answers." And he said, "What do you mean you're trying to get the answers? We're not answering those." And he said, "I told you to respond. I didn't say to answer." I really didn't know what that meant. I had never seen interrogatories, and I had never seen answers. So I really didn't know what he meant. And he said, "Give me those." And he took them, and he just wrote, objection. They had identified, for example, the product was, all hair colored product except the one that came in this box, but of the same make, that's this and that. And he said, "That's objectionable. That's very vague. We don't know what that is." And he went through and, he objected to every one. And he said, "Have your secretary type that up." And she did, and I handed him back to him. And and the signature line was for him. And he said, I said, as to objections, it had his name. And he said, oh, you can go ahead and take care of these. And I pushed him back and I said, oh, but they're already in final. So he signed them. But boy, that was an awakening. It was really a wake-up call. And later he said to me, he said, this case is going to settle. I mean, and I said, well, what if we had told them? What if we gave them everything they were looking for? How much would it be? And he said, really? And I said, really? Boatloads. So that was my introduction to so-called civil discovery. Now, this isn't to say that plaintiffs are free from blame in the process. Like I said, I'm biased. I admit that. And our clients are usually really grievously injured, so we're not talking about something we have to hide. I mean, it's usually somebody like dead in a plane crash. It's not like we're trying to hide the ball on something they did. So we're in kind of a different situation. We tend to turn everything over. I know that the plaintiff's bar is not, out there wearing halos saying, we always give you everything you ask for. But I do think that plaintiff's lawyers, for the most part, tend to not respond to discovery because they just kind of forget about it. It falls to the bottom of the priority list, number 10 after, respond to the motion to compel. And that is frustrating too. I mean, I know probably most of the lawyers in this room are defense attorneys, and I'm sure it's frustrating not to get your answers and your documents until you file the motion to compel. It's interesting because I guess I shouldn't call them the new rules. They've been in effect since '93, but in the new rules, a judge can still impose sanctions, and they specifically address that situation where after the motion to compel is filed, that's when you get what you want. And that doesn't necessarily mean the motion goes away. The judge is still free to impose sanctions, and they probably should. It's interesting because Philip Morris was a plaintiff in the Philip Morris ABC case, and they're typically a defendant. And what was funny about it is that they didn't change their tactics at all. They got a document request from ABC, and first they said they couldn't turn everything over because it was all protected, by trade secrets. Then they said they'd turn it over, but it had to remain confidential. And they had like 4 levels of confidentiality, that super confidential, and secretive. And they turned this stuff over, and I talked to the attorney whose case it was, the attorney for ABC, and he said, you wouldn't believe it, it's on this red paper, and it makes everybody sick. And I said, what do you mean? And he said, it's like toxic, it smells weird, and he said, you can't work with it for very long. The paralegals are all going home sick. And he said, you can't copy it. It doesn't copy. And I said, boy, that is clever. I mean, really, that's clever as hell, because then if there's one you want, what do you do? You have to call them up and say, we want to copy this, and then they're keeping a list, right? Saying, oh, they think that one's important. We want this one on white paper. But, and he said that some of the documents, and he said, I was working in New Orleans at the time on the Castano case, and we were trying to document share, which we couldn't do because of the confidentiality. And I said, well, can you give us an idea of what you got? And he said, all I can tell you is it's like a river of documents. It's so many. And he said, and I said, well, is it really confidential stuff? I mean, they seemed really worried about it. And he said, well, one of the ones I saw was a memo about cockroaches in the bathroom, and it was stamped highly confidential. So, it was kind of a needle in the haystack tactic, which happens a lot. I doubt very much that's the way that, I doubt very much that Philip Morris keeps their nicotine addiction documents in with the cockroach in the bathroom documents. I don't think they're kept that way in the regular course of business. That's how they were produced. And that happens a lot. And I don't know if anybody saw this, kind of low rent movie called Class Action, where the father and the daughter are pitted against each other, and there's this one document that's going to blow the case wide open, and they produce an 18-wheeler full of documents, and it's in there somewhere, and he's trying to really wear them down, or she's trying to wear them down. She's the bad guy, and they find the document eventually. But a lot of that really does go on, and it's too bad. Class actions have kind of leveled the playing field on that a little bit, because what you have now is you have wealthy plaintiffs attorneys with a lot of manpower and a lot of incentive, because in a lot of these class actions, they also bill by the hour. They're keeping their billable hours just for, just like the defendants do, because at the end of the case, there might be Lodestar, there might be whatever payment method's going to require them to turn over their hours. And I think that as a result, a lot of the same stuff is now going on. The plaintiffs' class action lawyers are doing a lot of the same stuff that the defendants have typically done. In the cases we've been involved in, that actually hasn't happened, but I do know, I read an interesting opinion the other day by Judge Brazil, who is kind of a leader in this field, the field of civil discovery, and he wrote this opinion that basically said, I've aged 10 years in this securities litigation from these discovery disputes. And in his opinion, both sides in that case had used the discovery process as a means of gaining leverage. I think the stakes are so high in cases like that the abuse is more prevalent, because both sides are kind of fighting for their lives, and it really gets out of hand. But again, the cases we've been involved in, we're involved in this pedicle screw litigation, and I think every lawyer on the planet has touched it at some point, so there's probably some lawyers here who are involved in it. And it involves another case.
Before you get into that, we've laid out the problem. Now Judge Easterbrook is going to give us the solution, since he writes the rules.
Thank you. A smooth segue. Discovery is both a tool for uncovering facts essential to accurate adjudication and a weapon capable of imposing large and unjustifiable costs on one's adversary. Litigants with weak cases have very little use for bringing the facts to light, and every reason for imposing costs on the adversary. And in almost every suit, one of the parties has a distinctly weaker case than the other, and therefore an incentive to do that. Now, the prospect of those higher costs, even if it doesn't change the outcome of trial, since most cases aren't tried, will lead the other side to settle on more favorable terms. In settlement, parties can divide the savings from not going to trial. But the way in which those savings are divided depends on their ability to bluff, their endurance, and so on. In other words, on factors that are unrelated to the merits of the case. So a party in a position to threaten exhaustive discovery or to string out the responses to the other side's discovery can claim for itself in settlement a portion of the cost that shouldn't have been incurred in the first place. That's the problem of discovery abuse. Now, before I get any further, I want to define some terms which I'm going to use. A normal discovery request, as I define it, is one in which the demander's costs of pursuing or resisting the request as it sees things are less than the increase or change in the value of the anticipated judgment that the demander expects the new information to produce. Now notice that that's a normal request, so you'll spend $100 on discovery if it'll change the judgment by $200. And notice that in defining it that way, I've completely ignored the cost of the other side of responding, because that's the way our legal system is set up. I'll come back later to whether that's a good idea. An impositional, abusive, if you will, discovery request is one justified from the demander's or resisting party's perspective, not by its contribution to the anticipated judgment, but by its contribution to an anticipated settlement. Stated differently, an impositional request is one justified by the costs it imposes on one's adversary in litigation, rather than by the contribution the information will make to the accuracy of the judicial process. Now, it's worth noting that both normal and impositional requests, normal and abusive requests, may inflict on the responding party costs greater to the responding party than the social value of the information. From the perspective of the party who's required to produce the information, normal and impositional requests are very hard to tell apart. Because for the producing party's purposes, this difference is immaterial. And this is going to be a source of some of the problem when we think about what to do about abusive discovery. I think that judges can do very little about impositional discovery when parties control the legal claims to be presented and they conduct the discovery themselves. The timing is completely wrong from the perspective of the judge. The plaintiff files a sketchy complaint and off goes discovery. The judicial officer, whether it be a judge or a magistrate judge in the United States, doesn't know the details of the case the party is going to present. After all, the theory is that discovery is used to find and fill out the details. Even when the judicial officer spends a lot of time trying to supervise the case, the judge always knows less than the parties. And the parties themselves may not know very much where they're going or what they expect to find. One reason for engaging in discovery is precisely that you don't know what to expect to find. So a magistrate supervising discovery can't know the expected productivity of a given request or the utility of a given answer, because the nature of the requester's claims and what's in the files or interrogatory answers is unknown at the time the judge comes to rule. Judicial officers can't measure the costs and benefits from the perspective of either the party requesting or the party resisting discovery. And as Judge Lamberth has just told you, appellate judges sometimes do this even worse than trial judges, if that's possible. Requesters don't have any reason to disclose their own estimates of how useful the information is, and parties opposing discovery don't have any reason to disclose their own estimates, because that may be terribly useful information for one's rivals. And it therefore seems to me that the portions of the rules of civil procedure calling on judges to trim back excessive demands therefore have been and are doomed to be futile. You can't prevent what you can't detect. You can't detect what you can't define. And we can't define abusive discovery practices except in theory, because in practice we lack the necessary information to draw the line. Even in retrospect, it's very hard to know whether a request or an opposition was abusive. How can a judge distinguish a dry hole, common in litigation as well as in the oil prospecting business, from a request that wasn't justified at the time it was made? Supervision by a judge, the message I'm giving you, is no panacea, because even the judge who resorts to all of the tactics in the manual for complex litigation can't do much. Why? Well, I've given you one reason. It's the lack of information the parties may have. And there's something worse than that. There is the plasticity of legal rules. The tort system is supposed to be about what a reasonable person would do, or a defect. About materiality, which is in securities litigation, which is what a reasonable person would want to know in the conduct of his or her own affairs, discounted, of course, by the probability that it will matter in the conduct of their affairs, and so on. Well, I could go on. Justice Holmes once thought that a developing legal system would reduce disputes of this kind to decision by rule, and therefore avoid the kinds of difficulty of application that we experience. For him, progress lay in making a transition from open-ended reasonableness requirements to defining what reasonableness consisted in. Holmes may have been right in defining progress, but he was a lousy prophet about how the judicial system would behave. Most complex disputes these days are governed not by rules, but by standards. Amorphous agglomerations, lists of factors that have to be considered and balanced, usually without much way to reduce those things to a metric no way of telling what happens when they conflict. When that is the substantive legal standard, it is essential to request information in discovery and impossible at the time to know which requests were justified and which not, because the structure of the rules that are going to be applied later on makes that almost impossible. And requests to change this structure have been very highly resisted, in part because it's very hard to carry out Holmes's program, even if you were minded to, and in part because many judges believe that considering everything is a virtue beyond price. Well, multi-factor standards cut down on loopholes, but at great costs, and the cost of running the discovery system is one of those costs. Lawyers can't limit their search at the time because they don't know what's going to turn out to be important. In responding to requests, it is rational for people to try to withhold as much information as they can because they don't know what's going to turn out to be important. And if nobody knows where to stop at the level of the practice of law, it becomes impossible for a judge to try to regulate this process. Now, what's to be done? Well, the kinds of things that were done in 1993 in the amendment of Rule 26 and some of the other amendments, like reducing the number of interrogatories and depositions and requiring self-initiated disclosures, seem to me completely unlikely to make headway. The numerical limits are unlikely to make headway because you can always subdivide things. And in any event, who knows the right number? If one knew the right number of interrogatories and depositions, the judge could just reach out his finger and say, there they are, without the need for changes in the rules. So too with proposals to require self-initiated discovery. People will be cautious about what they turn over. Let me put it that way. I'm not attributing any bad motives to anyone. Notice, I think people respond rationally to the incentives that face them. They're not doing this because they're mean. They're doing this because they're rational. The judicial system presents them with incentives. And so too, I think, with proposals, as many of them now enacted in Rule 37, to provide sanctions for abuse of the discovery process. The story I've been giving you is that it is impossible, almost impossible in theory, and certainly impossible in practice, to define abuse except in the Looney Tunes cases where somebody in a securities case asked the defendant to disclose whether it was raining on the day when he filed the prospectus. Right, well, everybody can see that, but there isn't any cost associated with making the objection. The ones where that are both costly to make and costly to respond to and costly to litigate over, you can't define what's abusive. Now, I ought to concede, having just condemned what happened in 1993, or at least said I didn't expect it to have much effect, that we do have a natural experiment underway. The changes made in 1993 were put into effect in about half of the districts. They were not put into effect in about half of the districts. Those districts that did and did not put them into effect had variations under their Civil Justice Reform Act plans. And there's an empirical study underway. The RAND Corporation has gathered a lot of data. We hope it has asked the data the right questions. The reports are in the process of coming out. And then people like the Pat Higginbotham and his Civil Rules Advisory Committee and the Standing Committee on Rules of Practice and Procedure, the Committee on Court Administration and Case Management are going to try to do something to change the rules if we can identify empirically those changes that have been successes and those that have not. Judge Lamberth said there were members of the Standing Committee here today. There are. I am one. Saul Schreiber, who is sitting out there, is another. Bill Wilson, who will be a moderator on a panel tomorrow, is a third. Maybe more have snuck in and have not come to my notice, but you should be talking to us. If you have either data or responses to the RAND data when you see it, and I hope you'll all look at it, come talk to us, send us letters if you want, write articles if you've got the time. Because I'm not, let me tell you, in my role as a member of the Standing Committee, my role as a judge for that matter, I'm not interested in anecdotes. Everybody's got a lot of anecdotes and they all look differently. It's like the old story of blind men describing elephants. Well, that's anecdotes in litigation. I care about data. I'm interested in whether particular changes in the rules can reduce the cost of discovery without jeopardizing our ability to reach just conclusions in litigation. That's very hard to know, but if you have a take on it, come tell me. Tell Saul. Tell Bill when he's here tomorrow. This is important stuff. But I will give you, since we're still bereft of this data, it does seem to me that I don't expect, I can be proved wrong here, I don't expect the changes to produce significant results in the cost or speed of litigation, or at least not if we're going to try to hold accuracy constant, because none of the changes has done anything about the principal costs of impositional discovery that I've identified. And that's a shortfall in information on both sides and the great plasticity of legal rules that makes it very difficult for us as judges, us as lawyers, to know what is justified, even ex post. I think legal uncertainty is the godfather of discovery abuse, and that uncertainty comes not only from nebulous rules in traditional subjects such as torts and contracts, but also from attempting to hand to the courts problems that are not suited to judicial resolution. Asbestos litigation, institutional reform litigation, and the like create problems in discovery because it's hard to see, even in principle, how a court can resolve them. If you put a question to the wrong social institution, it's no surprise that the institutions that have been devised for ordinary one-on-one litigation do not work very well. So the structure of our legal system is contributing to this difficulty. We put the parties in charge, we use notice pleading, we hope that discovery will identify, help us figure out what to do, but in a world where we're not willing to say what the dispositive legal issues are. Now, other countries have coped with the problem, but in very different ways. Think, for example, about a standard in Europe where a judicial officer takes control of the case right from the beginning and decides, the judicial officer decides what discovery is appropriate, where party-directed discovery is not the norm. Once the judicial officer has made a legal determination that some fact is important, that it's likely to make a difference in the outcome, it's easy to decide what ought to be acquired in discovery. The discovery is flowing from the position on what matters under the law. And if the case is unresolved after the judge applies to the law to what's discovered in phase one, you next ascertain the next appropriate inquiry and have discovery concerning that in multiple ways. But this method of controlling discovery, which the Europeans seem to like, and they seem to identify us as barbarians whenever our legal system begins to intrude on theirs, really reverses two things that have been held dear in American litigation, at least since the civil rules of 1938. One is that it puts a preliminary assessment of the merits ahead of the decision about discovery. And two, it puts the judicial officer rather than the counsel in charge of discovery. And as I say, litigants in nations that proceed that way are less worried about discovery abuse than we are. Not zero, but less, I think. If you think a system in which judges pare away the issues and focus investigation is just too radical to contemplate in this country, and it certainly would demand a very fundamental change in the way litigation is conducted, then it seems to me we ought to be prepared to pay the piper. If we insist on running litigation in a way that makes abuse of discovery happen, we shouldn't complain about the abuse of discovery, right? You don't complain about the symptoms of viruses and bacteria. The real problem is the bacteria, right? One ought not focus on symptoms. One final observation, which our next speaker is going to address, I gather. If neither a simple legal system nor one run by inquiring magistrates is attainable in the United States, I think there's only one change that holds a significant prospect for curtailing discovery abuses. The impositional discovery really depends on asymmetric stakes. The requester or the resistor, depending on which side is abusing, incurs lower costs than the other side. The requester saddles its adversary with those costs to improve its bargaining position. Well, we could do what every other civilized legal system does, or maybe I should say what every civilized legal system does, leaving open the question whether ours is civilized, and deny the abuser the fruits, requiring it to pay the costs that have been imposed. That doesn't mean sanctions. I've been telling you why I think sanctions are a mistake. They don't work. Because when legitimate and impositional requests look alike, The threat of sanctions is hollow. Only an automatic reversal of costs is likely to do the trick. The party always knows better than the judge which requests are legitimate and which are impositional, and a requirement that the party bear the costs imposed by that choice will remove the asymmetry of the stakes. Now, of course, a proposal to require losers to pay winners' fees invariably produces the rejoinder that will freeze poor persons and those of modest resources out of court. We don't think that's likely. The poor routinely are excused from paying costs now, and such an exception would apply to any loser pays system. The threat of taking from those who have nothing is not a realistic threat. And it does seem to me the bar can spread some of this through the risk sharing that now goes on in many class action suits where they now realistically pay the costs anyway. But even if all of that is true, much of the impositional discovery goes on in big stakes cases between people who are quite solvent on both sides, and I see no reason why we should let the tail wag the dog. When there are categories of cases in which cost shifting is realistic, I see no reason why it shouldn't be used. So let me sum up. I think the source of discovery abuse has nothing to do with the rules regulating discovery. I think, maybe the Rand study will prove me wrong, but I think it can't be fixed by tinkering with Rule 27, Rule 26, Rule 33, Rule 37, or any of their companions. Moving supervision from judges to magistrates or magistrates to judges or the district court to the Court of Appeals, and promulgating codes of conduct in which people are urged hopelessly to disregard all the economic incentives facing them is of no utility. It can't even detect those things that are problematic requests. The source of the problem lies, I think, elsewhere. In the structure of legal rules, there's too much uncertainty. In the allocation of fees and costs, they ought to be borne by those who cause them to be incurred. In the operation of the judicial system, there's too much litigant-directed and not enough judge-directed. Unless our legal culture is prepared to address the sources of discovery abuse, we shouldn't bemoan the symptoms. Thank you.
I wish you were in the DC Circuit. Next, John Heaps is going to tell us about the dramatic things that are going on in the United Kingdom. John?
Thank you very much indeed. Good afternoon, ladies and gentlemen. I am very honoured to be here this afternoon in such august company. I must say that I found the discussion this morning to be absolutely fascinating. I think that you will discover that a lot of what I have to say has got echoes in some of the things that have been happening in your own jurisdiction recently, and you will probably hear something of what Judge Easterbrook has just been telling you. But I hope also that you will identify some significant differences that are born out of my own system and certain of the reforms that are going to take place shortly. And I hope, therefore, that you will learn something as a result of what is just about to happen. First of all, I ought to say that I am reliably informed that James Madison, the inspiration of your society, was the president during the last war between the United States and Great Britain. And you may wonder how that all worked out. Well, I understand we talked at his house. It looked okay to me when I drove past from the airport. So all I can say is if his spirit is still in this room, I'm very sorry. I was fascinated this morning by the discussion about class actions. My own little story about class actions is that I, a number of years ago, acted for a company that manufactures carpet in a place called Brighouse in Yorkshire in the north of England. And they had the misfortune of supplying the carpet to the floor of the casino of the DuPont Plaza Hotel in Puerto Rico. And they, along with all the other companies that were sued in that piece of litigation, were joined in the action, and we received the famous letter from the committee of the plaintiffs, chaired, as I understand it, by the judge, which said something along the lines of, "Dear defendant, you may recall the MGM fire disaster a few years ago. We wrote a similar letter to all the defendants in that case, and we offered them the opportunity to settle the litigation, which they turned down, and we have to explain to you that it cost them a great deal more defending it. I met a few years ago a lawyer from Chicago who I was relating the story to, and he said, "Oh, gee," he said, "you had the killer carpet." He said, he said, "I was for the killer floor wax." Anyway, firstly, listen to these two quotes and see what you make of them. "The costs of litigation are higher here than in any other state in which we operate, except possibly for the state of California." And the second quote, "The representatives of a leading international bank inform me that they are giving consideration to changing the venue for resolving disputes to New York." Now, those quotations come not from a report on the state system of Utah, and they do not come from a report on the state system of Alabama. They indeed come from a report on the state system of England. And during the last year, we have been going through the most extraordinary period of reconsideration of our own system, which resulted about a month ago in the production of this document, which is the final report of Lord Wolfe, who was commissioned by the Lord Chancellor to prepare a review of our English legal system. And during the course of the next 2 years, we have decided, apparently, to throw away the rule book and start again. And there is another document which is just about as thick as that, but I couldn't bring it with me because I would have been over my baggage limit, which is the new set of rules, which is going to completely replace the rules that we have been working under for the last century, plus all the case law. The whole lot is going to go straight out of the window, and it's going to be replaced by a new system. And that is what I'd like to talk to you about today. Now, before I start on that, I think there are just 2 or 3 things that I need to say about the differences between the systems in the States and the systems in England. Cross-cultural comparisons are all very well, but I think they can be dangerous at times. After all, it's said that England and America are 2 nations divided by a common language, or maybe as a result of what I've heard today, the common law. The following need to be considered. First of all, costs. As you probably all know, in England, it's the winner takes all. If you prevail in litigation, then you're going to be paid about half to 2/3 of the costs that you've incurred. Secondly, we do not have contingency fee litigation, at least not in the way that you understand it. Poor people are supported by the legal aid scheme. So there's nothing in England for John Grisham, and I don't expect to see the next novel based on our legal system. Secondly, damages awards. They are decided by a judge sitting alone, except in defamation cases. And there are no punitive damages. The damages awarded in English courts are purely compensatory. Lastly, discovery. And I think, as I said, language is dangerous unless you understand the terminology. The word discovery in England covers only the exchange of documents. It does not cover the other aspects of the investigation prior to trial. So, for example, we do not have depositions. We do have interrogatories and we have requests for particulars, but what I'm particularly talking about today is the exercise which we describe as the exchange of documents. That's the background. Now the Wolfe reforms. I've shown you the book. Wolfe recognized the real mischief at the moment as being the expense of litigation. He describes expense in litigation as a cancer eating away at the heart of the administration of justice. And what he believes, and this is central to everything that he said, is that litigation should be affordable. Accordingly, many of the reforms that he has talked about, which are going to be introduced in my country, are intended to make litigation more affordable. I'm not convinced that that is necessarily an issue in this country, but that is certainly the way that he has approached it. Now, Lord Wolfe talks about a new landscape and a new procedural code. There is a paper available if anybody would like to collect it, and at the back of the paper I've set out Rule 1 of the new procedural code. And what the courts are going to be required to do is to conduct the cases before them justly, according to the following principles. First of all, and you may all ask yourselves as I'm going through these points, what does all this mean? And there are a lot of lawyers in England who are certainly at the moment saying, what does all this mean? I mean, civil justice reform doesn't usually make the heartbeat faster, but I can tell you there are heart attacks and palpitations going on in my country at the moment. So they've got to work out that the case has got to be run justly, bearing in mind the following. There's got to be equality between the parties. There's got to be economy in the use of resources. There has to be proportionality. Now, proportionality is a word that already exists, as I understand it, in Rule 27 of your own system. So you'll recognize that word. You'll also recognize that it's utterly meaningless as far as your own system is concerned. But it's proportionality as to the amount at stake, the importance of the issues, and the party's financial position. All very commendable stuff. How is he going to achieve all these commendable aims? And how on earth are the courts going to deal with these matters with skill and, perhaps most importantly, consistency? There are three rule changes that I particularly want to draw to your attention this afternoon. And they relate specifically, really, to this discovery exercise. The first is the question of pleadings, the second is the rules related to discovery itself, and the third is the question of costs. Dealing with pleadings, we have a much more detailed pleading system than you do. Notice pleading, as you have it, what a misnomer. It doesn't give notice to anybody of anybody's genuine case, as I understand it. We have a much more fully pleaded situation, but Wolf believes it's all too formalized. What he wants to get to as quickly as possible is the idea that the judge, within a matter of weeks of the start of litigation, will be drawing up a list of issues between the parties at a case conference, which would be used as the basis of everything that thereafter happens in relation to the litigation. And those issues would determine particularly the discovery exercise. Second, discovery itself. Under the current rules, discovery, as I say, is just an exchange of documents. And at the moment in England, the definition of relevance is very wide indeed. But I think the particular point that I want to draw to your attention, most of all, because it's been fascinating listening to some of the problems that you've got and how it sort of translates into my own experiences, is the duty that a solicitor in England has got to the court in relation to the issue of discovery. I'll tell you what I mean. We're in the middle of the case in my office at the moment where we're acting for the defendant. The other side sought to support their claim by relying on the chief executive's diary. It emerged at trial that extracts of this diary were in fact incomplete. Now, when this emerged at trial, the lawyer, the solicitor on the other side, was put into the witness box and cross-examined by the judge. And I'm just going to read you the transcript of what the judge said just before this solicitor went into the box. And I've changed his name. Because Mr. Jones is an officer of the court, discovery is a very sensitive matter. And on the face of it, there has been the most appalling failure to disclose what can only be described as pivotal documents in the case, an astonishing neglect to ask for the obvious. I say here and now that it may not stop here, depending on what Mr. Jones has to say. Now, Mr. Jones is the subject matter of a disciplinary investigation by the Law Society at the moment, and on Monday we have an application to the court that the solicitors on the other side pay the costs of the action. And I'm talking of 60, 70, 80,000 pounds. So when you talk about the obligation in relation to discovery in England, it is the imposition of this duty on the solicitor which is absolutely crucial, which usually means that those key documents do not remain submerged at the bottom of somebody's filing cabinet, because it's the risk and the fear of retribution that drives the solicitor on. Now, the problem that Wolf has recognised is that because that duty is so extreme, you get discovery by avalanche. I mean, people will overreact to make sure that they're keeping clean. And so what he has identified under the new rules is that there should be 4 categories of discovery, and they read as follows. The documents on which you intend to rely, pretty obvious. The second category, I think, is the most difficult. Adverse documents of which your client is aware, not the solicitor, which to a material extent are going to damage your own case or help the other side. Those are the first 2. Then there are 2 others. The documents that are really part of the story, they just fill in the detail. Nothing's going to turn on them, but they tell the story. And finally, this rather bizarre line of documents called train of inquiry documents, which may or may not enable one of the parties to advance his case. What Wool says is that the only documents that are going to be automatically discovered are the first 2 categories, the ones you rely on and the ones that are adverse. If you want the other 2 categories, you're going to have to demonstrate to the court that you are really entitled to them. And what is going to emerge is that the court is probably going to say that in a marginal case, the cost of the exercise on both sides of looking for those documents is going to be paid by the party who is seeking the discovery at that stage. Now, if it turns out, using Judge Easterbrook's analogy, that the oil well is genuinely an oil well with oil in it, then the order could be reversed at final trial. But it's the idea that if it's marginal, then it'll concentrate people's minds a great deal more if they think they're going to have to sign a cheque at that time if they want to pursue it any further. Finally, turning to the subject of costs, very quickly if I may, we all know the English rule, it's simply winner takes all. Wolf believes it's a blunderbuss. He thinks we should have an Armalite. And what he would like to do is to segment the case into little bits and apportion costs depending more on the conduct of the case than on its outcome. And he thinks that with the skillful use of discretion by the court, and that's a big if, it seems to me, it's more likely that fairness will be done between the parties. Because if somebody wants to pursue a particular line of inquiry, then the court will require them to pay for it, either there and then, or at the end of the case, when in retrospect you can work out pretty easily whether or not it was something worth pursuing or not. In conclusion, let me summarise before we pass the discussion to the floor. The problems of discovery in England are not the same as the problems that you have experienced, but there are definitely parallels that you can draw. The way ahead for the UK is clearly increased case management, and you may fear for us or not, I simply don't know, but it'll be interesting to see how we get on with it. But with a difference, and I think that the ability of the court to make these sophisticated court orders are going to help deter the waste that has blighted our system, certainly, in the past. There is at least the hope that if this waste does occur, then the abuser will have to pay. Thank you very much indeed.
John and I talked at lunch. I have a little nervousness about England moving in the direction of thinking that the hands-on management judge is the solution to all these problems. That's certainly what we've tried to do in this country. That's what the rules are envisioning, these hands-on manager types of judges. And as I've demonstrated today, that doesn't necessarily work. Be glad to take questions. Yes, sir.
You ask about data. I'll give an anecdote and ask if you have data, and that is dealing with special masters. In federal court, the use of a special master seems to resolve discovery disputes in 3 to 5 days. You might even have a master sit in on a depot if they're getting that cantankerous. And since both parties have to pay, there is an incentive to use the person less, and to once you realize the master's going to take an active role in settling these disputes, they seem to go away. That's personal experience. I've seen no data about to what extent federal judges are using them, but the cost sharing at a high hourly rate is a disincentive to use that individual and to solve the dispute yourself.
Perhaps this is something that Saul Schreiber will talk about, since he's played that role and is now in line. I agree. I would love to see data on the utility of special masters and the extent to which they actually succeed in reducing costs. I'm aware of good anecdotes and bad anecdotes about them, but I'm not aware of good data, so I would hope it can be found.
Yes, ma'am.
Judge Easterbrook, also I wanted to follow up. There is a draft available of the RAND report, and it does confirm, in fact, what you suspected, that the discovery reforms have basically been a non-starter.
Yeah, well, I'm not entirely sure yet that the draft is where we will end up with. I don't want to get too technical. There was a 7% open tail on the sample. Basically, 7% of the cases they had in the sample, they didn't know how they had come out because they were taking longer. And the ones that took the longest are the ones that had the most problems. So although I could have said, gee, the draft backs me up, I will be more happy when it's all done and we've got all the data in the real final version.
Yes, sir.
Scott Brister from Houston. I sense a consensus, at least where I'm from, that there's too many lawsuits and that discovery is too expensive. Now, the economists tell us if you make something cheaper, you'll get more of it. Am I missing something? Or isn't the effect of limiting and cutting down on discovery and making it cheaper going to end up in more lawsuits?
You didn't hear from me that there were too many lawsuits. You heard from me that lawsuits are too expensive. You didn't hear from me that there are too many. You know,
Well, but I think that's a consensus in the country. You can do a poll, I think you're going to find a huge majority of people that think, certainly on the
everybody
jury,
thinks that there are too many lawsuits except the one he's a party to as a plaintiff. What the right number of lawsuits is extremely difficult to figure out. The right number of lawsuits would plainly be 0. We could achieve that in a world where no one broke his contract, there was no negligence, and so on. You can't achieve that. You need a positive number of lawsuits to get the rules enforced properly. I mean, assuming that judges and legislation are properly defining the rules that need to be enforced. I really don't know what the optimal number of lawsuits is, although my whole point was that they're too expensive for what we have. So I'm not a member of the bandwagon who thinks there are too many lawsuits.
so if we lower, there probably will be more lawsuits.
It is extremely difficult to tell. If you both lower anticipated costs and engage in cost shifting, there will be fewer weak lawsuits filed and more meritorious lawsuits filed, because there'll be more small stakes meritorious lawsuits that people can afford to bring. What the aggregate effect will be is very difficult to say. There's a very large theoretical literature on this, which does not reach a firm conclusion on whether it will go up or down. And the cross-boundary studies are influenced by so many other things they don't really tell us. And I can tell you one interesting fact. Florida isn't the only American jurisdiction that has put in regular cost shifting. Another American jurisdiction that's done that is Arizona. And the number of business lawsuits in Arizona as a result of cost shifting has gone up. The more meritorious lawsuits, in fact, dominated.
Judge Easterbrook, even before the federal rules and even before the field code in New York, there was in fact discovery, even though there were no discovery rules.
Mm-hmm.
And the lawyers carried the discovery out voluntarily. And the sanction that made them carry it out voluntarily was the fear that they would be accused of surprise at trial. So although this system wouldn't work in its pristine form today, there's an element in it that was very good, which was you determined whether people had made fair discovery by the results. And what we got when we gave up that system was abusive discovery. Discovery's always had an abusive element. And isn't there a way that we could return to the idea that you determine whether discovery was adequately made by the results at trial, and you make discovery voluntarily as long as it's complete, the way it was at common law?
I'm not sure it was really even voluntary, but at common law there were legally obligatory elements. You know, we have these days a system that is very similar to that. We call it criminal law, where the prosecutor may or may not open his files, and if the prosecutor doesn't open his files and something comes up at trial, the defense lawyer will raise his hand and say, Your Honor, I want a continuance. And that so disrupts the case that the fear of that causes the prosecutor to disclose more. But if we're at the level of anecdotes still, because I don't know of good data on this one, you'll have a lot of defense lawyers who say, even at the end of the case, the prosecutors are sitting on a lot of Brady information that they haven't turned over and which I think will come out. There's a lot of cases where the end of the case comes and people will make an assessment, but they still lack all the information necessary to make the assessment at the end of the case.
I think in truth, one of the data questions Judge Easterbrook talked about is very interesting because I came as a judge with a total civil background to the bench and tried nothing but drug trials for my first several years on the bench. So it was a rude awakening to see the difference in discovery in criminal versus civil. Yet I do not know of any studies that give you any data about the difference in how civil and criminal discovery are conducted.
This is basically a problem with lawyers. Lawyers really love to talk, but number crunching doesn't come naturally. That point was made on the scientific evidence panel. And I'm not speaking to either side. It's a cast of mind that entertains different propositions about rules and outcomes merely as hypotheses to be tested by data. That's a cast of mind instilled in universities in the hard sciences. It's not instilled in law schools. It's not rewarded at the bar. And of course, the gathering of data is largely not rewarded. So it's no surprise we have this different attitude.
I wonder if I could also just add that the thing that probably concerns most lawyers in England is that this report by Lord Wolfe, if you read through it, the amount of concrete, hard evidence about the problems of the English system is very, very hard to find indeed. And you talk about empirical evidence, and there just isn't any. It's anecdotal. And it's the sort of quote that I read out to you at the beginning about representative of a leading international bank. So what?
Yes, sir.
Mr. Heaps, would you tell us if the Wolf's recommendations dealt with contingency claims, class actions, and what will happen to the taxing masters?
I think the taxing masters are going to be very busy indeed, I think is the first point to make.
I don't know if the audience know. Would you?
Yeah, I'll explain what a taxing master is. One of the features of the system, namely that if you're going to have a cost switch, is that the lawyer's costs are going to have to be assessed by the court. And the person who assesses the costs is the taxing master. And so what you have to do, and it's an extremely painful exercise, is go down to London in front of the taxing master with all your files on this massive case, and for days on end justify every telephone call and attendance and meeting and document that is being prepared. And that of all the things that induce a settlement, I can promise you, it's the one thing more than any. So that's the thing about taxing masters. So far as contingency fee litigation is concerned, it has been introduced into England. We call it by a different name. It's called conditional fee litigation, but it's a much more modest version of what you have got. So much so that the maximum cap, I think, is the equivalent of 100% of what you would have earned as the lawyer on the case had you been working on an hourly rate. Class actions are, I don't suppose that would impress Mr. Poorboy. Sorry, it wasn't Poorboy, was it?
Corboy.
Freudian stuff. The problem with class actions, I think, like McDonald's, Disney, and nylon stockings, it's on the way over the Atlantic as we speak, and we haven't really had as much experience in England yet as you have had over here. But certainly, class actions are as an intractable problem in England as they are in this country, and I don't pretend to have any answers for that.
Yes, ma'am.
Well, here's a very non-quantitative question. The comment that struck me most in listening to this discussion was by the first speaker, which had to do with tobacco litigation cases of people, it now comes to light, withholding documents and apparently willfully withholding documents from discovery requests. And this reminded me a little bit of the comments that have been made by people like Marianne Glendon about the decline in ethics of the profession. And I wonder if you feel whether the profession comes down hard enough over things of that nature. And it sounds like some of the cases where you produce a warehouse full of documents in order to, because there's one box of relevant documents there. One could also say after the fact, this really looks like willful abuse of the process, not something that should generate a $25,000 fine or a larger fine, but simply the awareness this is flat out unethical and people should have their legal licenses in the dock. And is in the cases where you can say, yeah, that really is an abuse of discovery. It's not a close case with balanced arguments. Does the profession come down hard enough? Is there anything more that could or should be done there?
I agree with that. I think that if a lot of times what happens is I think this stuff is client directed. I think that as has been pointed out, people aren't really inherently mean, but the client is saying, you know, don't turn that over or don't do this, don't do that. And that's who pays your bills. So you want to do what makes your client happy. But if you thought you'd really get in a lot of trouble, if you thought you might lose your license, if you thought you might be disciplined, if you thought that you as the attorney might be paying $25,000 out of your pocket, I don't think that kind of stuff would go on as much. And I agree that something more should be done ethically when things like that happen. I think that, though, at the end of the case, that when everybody's all worn out, nobody's running to the bar to complain about that stuff.
I must say I agree completely with that. The bench should do much more to police these things. That the bench is not nearly hard enough on these kinds of violations, but I bet if you took a poll of the Seventh Circuit Bar Association, you would get a different answer about the Seventh Circuit on this question. The usual complaint of the bar is that we're much too hard and hyper-technical and stuff like that. There's a very large gulf in that respect between how people feel after being on the wrong end of it in a given case and how people feel about the general riskiness of the practice. If a sudden change were made to the English practice where the lawyers were on the hook for all the discovery costs personally, I think you'd find a lot of people squirming and telling us that wasn't consistent with justice and so on.
Yes, sir.
I do have a question about the UK, but I wanted to start with another comment or two about Florida because it is more complicated than we've been hearing. Florida enacted loser pays only for medical malpractice claims, and there were several problems that eventuated in practice, of which I'll only mention one. There was indeed a substantial rise in the number of what appeared to be strong small claims. So far, so good, you might conclude, except that the manner in which they were prosecuted turned out to be very perverse. Because the law guaranteed the lawyer a full fee shift at the conclusion of a winning case, regardless of where the damage award came in, the lawyers would get the meritorious small claims and then refuse to settle them, carry them all the way to trial, and get a fee award that was often, very large proportionally. After an award had come in, which was in many cases lower than settlement offers made in the first couple of weeks. And any loser pays system in other countries would wind up defining this as a defense victory, either through the British offer of settlement rule or through the various continental systems. Florida did not. Florida had a very freakish blueprint, which should not be seen as a proper trial of loser pays. Yeah. Now, to get to my...
That just sounds like a glitch, but the people who may not know what Walter's been referring to, jurisdictions that have loser pays, real loser pay systems, require both sides, in one or another way, done differently in different nations, require the plaintiff to say someplace near the beginning of the case, here's what I demand, and require the defendant to say, here's what I offer. And they define as the real stakes of the case only the difference between those two numbers. And if that number is negative at the end of the case, the defendant has won it.
Correct. That is absolutely right. So effectively what happens is that the plaintiff, at the moment, without the payment into court arrangement or what Judge Easterbrook has just been referring to, if the plaintiff simply succeeded as to $10, he would obviously win and therefore recover his costs. So what is desperately important as a defendant is to make an offer to the other side which you know he's not going to be able to beat. And if he doesn't beat it, then the cost rule is reversed. And that is the thing that really drives the settlements home. Now, up until recently, that arrangement could only be made by the defendant actually paying a sum of money into court. You had to put your money where your mouth was. Wolf believes that that should be relaxed so that without prejudice correspondence, which obviously would not be referred to the judge at any stage before he reached his decision, but without prejudice correspondence could have a major impact on costs if the case ran its full life.
Last question.
Judge Easterbrook mentioned the need for more data, and the issue came up particularly differences between civil cases and criminal cases, the effects of discovery in the two systems. And the question then arises, how is such data to be gathered? And what sorts of measurements are you going to use to decide on the effectiveness of these different systems?
I haven't had much of an opportunity to think about it for criminal cases, but there are obviously differences across state borders. We have a very large federal system, and those differences create the ability to gather data and compare how they affect litigation. We've got at least 55 jurisdictions, the states, a bunch of territories, federal government, DC. And so we've got a large enough number that you can make some sophisticated inferences. This is what RAND has done, where we have 94 district courts gather the differences in their rules and then gather data about the cases and how long it took to resolve, and you then run a fairly sophisticated mathematical model of these things and discover which differences in rules accounted for which differences in cost, delay, amount recovered, and so on.
But the problem
And the
is that
statistical tools exist if you have enough variance across jurisdictions. Getting enough variance is the key to doing a study like this.
the difficulty is that that could only measure things like the length of time needed to resolve cases. It does not measure the quality of the resolution.
You can only measure what you can count, I'm afraid. That's the...
Thank all of you for your attention, and let me thank my panelists. I think they all did a superb job, especially our computer. Thank you very much.